Hello again, and welcome back to another edition of The Wicked Conservative. Today I have for you a New York Times article titled, "The Supreme Court Seems Ready to Throw Out Affirmative Action Programs." Guys, this is a very long article, so grab a drink and let's get started. The Supreme Court on Monday appeared ready to rule that the race-conscious admissions programs at Harvard and the University of North Carolina were unlawful based on questioning over 5 hours of vigorous and sometimes testy arguments, a move that would overrule decades of precedents. Guys, you've been here long enough. You know that precedent does not make good law. So let's go ahead and continue reading what they feel should happen in these cases according to precedent. Such a decision would jeopardize affirmative action at colleges and universities around the nation, particularly elite institutions, decreasing the representation of Black and Latino students and bolstering the number of white and Asian ones. Questioning from the court's six-justice conservative majority was sharp and skeptical. "I've heard the word diversity quite a few times, and I don't have a clue what it means," Justice Clarence Thomas said. "It seems to mean everything for everyone." And he's not wrong. Diversity hires have become an accepted practice in the business institutions. This affirmative action at colleges and universities has also become an accepted practice. But whenever you start judging people based on the color of their skin and not necessarily their actions or qualifications, then we seem to have a racist issue, don't we?
I'm smart.
Justice Samuel Alito asked a similar question about the term underrepresented minority. "What does that mean?" he asked, adding that college admissions are a zero-sum game in which granting advantages to one group necessarily disadvantages others. If the court does away with affirmative action by the end of its current term, it would represent the second time in the space of a year that its conservative supermajority has jettisoned decades of precedent to overturn a policy that has helped define American life, as its decision in June eliminating the constitutional right to abortion made plain. Members of that majority have not hesitated to take bold steps on divisive issues. So we are now comparing affirmative action to abortion. Does anybody else see what's going on here? The article continues on. "A ruling against universities would be further evidence of the court's rightward lurch after President Donald Trump's appointment of 3 justices, and it could raise fresh questions about whether the court's approach to precedent threatens the stability of law and the court's own legitimacy." Now, we again know that precedent is not law. So how could changing a precedent into standing law undermine the court's own legitimacy? That's kind of the whole point of the court. You have to make something into a law in order for it to be upheld in a court of law.
Congratulations.
That's how it works. Chief Justice John Roberts, who views himself as the custodian of the court's independence and authority, may have conflicting impulses in the cases argued Monday. He has long been critical of drawing distinctions based on race. His questions about race-neutral means of achieving diversity suggested he might be pursuing a characteristically incremental plan. That approach could limit the sweep of a decision rejecting race-conscious programs. In general, 2 themes ran through questions from the court's conservatives: that educational diversity can be achieved without directly taking account of race, and that there must come a time when colleges and universities stop making such distinctions, because making those types of distinctions is actually a form of racism. I think that we need to get rid of it. Three liberal members put up a spirited defense. Justice Sonia Sotomayor said, race does correlate to some experiences and not others. If you're Black, she said, you're more likely to be in an under resourced school. You're more likely to be taught by teachers who are not as qualified as others. You're more likely to be viewed as having less academic potential. So, just in those few short clips and phrases, to me, it seems like Justice Sotomayor is a little bit more racist than, say, your average college institution.
I'm smart.
You cannot sit here and say that just because of the color of somebody's skin that they are more likely to be in these scenarios. You can say that based upon certain incomes, certain living arrangements, certain areas of the country that you are more likely to be in these types of scenarios. But I do not believe that this really has anything to do with the color of somebody's skin. Justice Kente Brown Jackson said it would be odd if admissions officers could consider factors like whether applicants were parents, veterans, or disabled, but not if they were members of racial minorities. That has, quote, the potential of causing more of an equal protection problem than it's actually solving, unquote. The interesting comparison here is that she considers this to be equal. The color of your skin is equal to having babies, serving in the military, or having a disability. How is any of this equivalent to the other? You can make choices that determine whether or not you become a parent. You can make choices whether or not you become a veteran. And if it's not genetically related, most disabilities are also the result of life choices. So whether you took a job where it was potentially hazardous, you took a risk in your everyday life, or maybe you were just in the wrong place at the wrong time. These things can be prevented or can be compensated for. You can find ways to compensate for parents. You can find ways to compensate for veterans. You can find ways to compensate for disabled people. But what you cannot compensate for, or you don't have a choice over, is the color of your skin. In this case, in this scenario, especially when it comes to having academic potential, the color of somebody's skin could not be less relevant. Justice Elena Kagan said she was worried about a, quote, precipitous decline in minority admissions, unquote, if the court were to rule against affirmative action in higher education. Quote, these are pipelines to leaderships in our society, unquote, she said of the elite universities. Over the course of the argument, the justices discussed with seeming approval several kinds of race neutral approaches, preferences based on socioeconomic statuses, so called top 10 programs, which admit students who graduate near the top of their high school classes, and the elimination of preferences for children of alumni and major donors who tend to be white. So therein lies your problem. People on the outside looking in who see the generations of students who go to these acclaimed universities, these families who donate major dollars to these universities because they were their alma maters and they are sending their children there. All of this turns into a race problem, doesn't it? So, of course, for anybody on the outside, it looks like people are buying their entry fees, and not everybody can afford that. So, of course, it has to be Racist.
Congratulations.
Justice Amy Coney Barrett asked whether it would be permissible for minority students to write essays describing their experiences with race discrimination. Patrick Strawbridge, a lawyer for Students for Fair Admissions, the group challenging the program, said that was fine. What we object to, he said, is a consideration of race and race by itself. Absolutely. Personal essays are different, he said. It tells you something about the character and experience of the applicant other than their skin color, he said. Similarly, Mr. Strawbridge said, an Asian American student might write about traveling to a grandparent's home country. Chief Justice Roberts said that such a student would not be a very, quote, savvy applicant because, quote, the one thing his essay is going to show is that he's Asian American, and those are the people who are discriminated against. What are we talking about here? If it's a college requirement to write an essay and then get judged on the content of that essay for consideration into the school, then why are we caring about what necessarily is written about so much as how it is written? You can write 1,000 different types of stories, and they don't have to be personal. They don't have to have anything necessarily groundbreaking in them. You just have to have your mechanics down pat. You have to use capital letters, proper punctuation, proper phrasing, grammar, spelling, what format it's in. There's all these things that go into making a academic evaluation of a person based on a paper that they're writing for consideration for admissions. But whenever you put into the concept the idea that their skin color is what is the determining factor of whether or not they are allowed to be enrolled in a school, this is what the problem is. This is what the argument is. Based on race alone, that is discrimination. Whether you're discriminating for the benefit of that human being or you're discriminating against that human being so that they do not receive any benefits. But I digress. Seth P. Waxman, a lawyer for Harvard, later said it did not discriminate against Asian American applicants, though he did not contest that on average they received lower ratings for personal qualities at an early stage of the admissions process. Mr. Waxman said many factors contributed to whether students were admitted. Race for some highly qualified applicants can be the determinative factor. He said, just as being an oboe player in a year in which Harvard Ratcliffe Orchestra needs an oboe player will be the tip. So, what you're basically saying is that if your school is appearing to everybody on the outside as to be a racially discriminative location, and you get an applicant who is teeter-tottering the line, or say you have two applicants, one is a minority and one is not, and both are equally qualified. So you're saying that the tipping point will be the skin color of the student? Is that ultimately what this boils down to? And again, how is that not considered racist? Chief Justice Roberts seemed taken aback. Yeah, he said, we did not fight a civil war about oboe players. We did fight a civil war to eliminate racial discrimination, and that's why it's a matter considerable concern. And I agree with him. This is exactly what discrimination is. Now, again, we all hear the word discrimination and think immediately of bad things. But as we're finding out, discrimination can also go in a good way. They can discriminate in a way that makes you qualified for a higher education. Justice Kagan asked Mr. Strawbridge whether universities could put a thumb on the scale in admissions decisions to ensure that men were adequately represented in an era in which most college applicants are women. Mr. Strawbridge said that question would be governed by a less demanding legal standard than the one that applies to distinctions based on race. Kagan said the differing treatment would be peculiar, adding that white men get the thumb on the scale, but people who have been kicked in the teeth by our society for centuries do not. Well, Miss Kagan, I do not believe that that is what Mr. Strawbridge was trying to say to you. What we're trying to say to you is that most college applicants are women. So, going by the diversity constraints that you have put on these schools, taking in overwhelming applicants that are women need to be counterbalanced by applicants from men. These are your rules that we're playing by. These are your rules that you put in stipulations for these colleges. So, of course, now we have to play the diversity game. Mr. Strawbridge said there would be no preference for white men, but men in general could perhaps gain an advantage for exactly the reasons I just explained. If a majority of your applicants are women and you have a diversity quota, then you're going to have to start taking in some men as well. But I digress. Elizabeth B. Preglar, the U.S. Solicitor General, argued in support of the universities in both cases. When students of all races and backgrounds come to college and live together and learn together, they become better colleagues, better citizens, and better leaders, she said. Now, we've been looking into our college universities now for at least the past 4 years, and I tend to disagree with that statement. I don't believe that all races and backgrounds are coming together in college. They are actually becoming more segregated in college based upon the different student groups and student living arrangements and student areas and different activities that these kids are getting involved in. So I don't know when the last time that the Solicitor General actually went to a university in order for them to say that they learn to live together, they learn to become better colleagues and better citizens and better leaders, doesn't seem to be the case any longer. It seems like the colleges are factioning themselves out, and it's gotten so bad that we are in a Supreme Court decision. So obviously, this is an issue, and segregation is an issue in our colleges. So for her to even come and bring this to the table is ridiculous, in my opinion. She said that the kind of educational environment is particularly vital to the military and that other institutions, including the Supreme Court, still had work to do. Again, Elizabeth, I don't know what you're talking about. Why on earth should the Supreme Court have work to do on institutions? These are two separate areas. One is a arm of the government and one is an education institution from the people, for the people, by the people. So why again must we involve the court system in this process? In the 2 weeks of arguments that began Monday, she said 27 lawyers are scheduled to argue. Two are women, she said, and even though women today are 50% or more of law school graduates, I think it would be reasonable for a woman to look at that and wonder, is that a path that's open to me to be a Supreme Court advocate? Again, I'm not 100% sure where your brains are. But not every woman wants to go to school. Not every woman wants to be an attorney, and not every woman wants to be a Supreme Court advocate. So she says that 50% or more of law school graduates are women. 50% or more are women. So that to me seems like a pretty equal down the line number. Out of 100, there's 50, 100%, 50%. Not great at math, guys. Really not. But that's half. Literally half of the people. You can't even get a kindergarten class to agree in some sort of half majority that they like ice cream flavors or that they like gym class in school. So if 50% or more of women that graduate from law school are going into a path that they want to pursue, I don't understand where you're getting this idea that women are being held back. I don't understand why you think that this is a problem or why you think that there is discrimination afoot. The court has repeatedly upheld affirmative action programs at colleges and universities, most recently in 2016, saying that educational diversity is a compelling interest that justifies taking account of race as one factor among many in admissions decisions. When the court agreed in January to hear the two affirmative action cases, it consolidated them and said it would hear a single hour of arguments. The court decoupled the cases after arrival in June of Justice Jackson, who recused herself from the Harvard case in light of her service on one of the university's governing bodies. So, what they're basically saying now is that they had two diversity compelling interest cases that they stuck together in order to roll out this decision based on the multifaceted issues in these cases. But because one of their justices is personally entwined with one of the defendants in the cases, they had to split those cases, and Justice Jackson had to recuse herself from the Harvard case. So, even though the two cases are not identical, as public university UNC is bound by both the Constitution's Equal Protection Clause and Title VI of the Civil Rights Act of 1964, which bars race discrimination by institutions that receive federal money. Harvard, a private institution, is subject only to the statute. We go back into understanding the difference between a quote unquote public service and a quote unquote private service. As this article is telling us, the two cases are not identical. The public university, UNC, has two separate clauses that they are bound by. They're bound by the Constitution, which is equally what Harvard is bound by, but also Title VII of the Civil Rights Act. Now let's go back to all those alumni and those donors that they were talking about in the beginning of the article. Harvard, being a private institution, relies on those donations. That's why a lot of your white colleagues will end up sending their children to the same schools that they went to. They're funding those schools. They went to school there. They funded their education there. They're sending their children there. They're going to fund that school again, making it a private institution, making it so that if you're in the club, you get to go to that school. If you're alumni, if you're donors, if you're doing the thing and your parents have went there and your grandparents went there, chances are you're going to go there too. And it doesn't mean that they're discriminating against somebody. It's like being in a family. You don't just let strangers into your house every year around Christmas time because you want to be diverse. You want to have a diverse Christmas dinner. No, you go out and you will talk to your friends, you'll talk to your colleagues, you'll talk to your people that you know, and you'll invite them to your house for your Christmas dinner. Harvard is doing the same thing, only instead of a Christmas dinner, they're handing out diplomas and giving out an education. In the North Carolina case, The plaintiff said that the university discriminated against white and Asian applicants by giving preference to Black, Hispanic, and Native American ones. The university responded that its admissions policies fostered educational diversity and were lawful under long-standing Supreme Court precedents. Going back to the prior paragraph, the two cases are not identical, and institutions that receive federal money have multiple clauses and protections to guarantee that the diversity is upheld. But when you go into this paragraph, it says that these are just policies based on precedent, not necessarily equal protection clauses, not the Civil Rights Act, not anything at all other than what other people seem to view from the outside. Is this school diverse or not? But again, they're not referring back to clauses, equal protection acts, or anything that was passed legally. They are referring back to long standing Supreme Court precedent. Mm. Now, the case against Harvard has an additional element accusing the university of discriminating against Asian American students by using a subjective standard to gauge traits like likability, courage, and kindness, and by effectively creating a ceiling for them in admissions. Both cases were brought by Students for Fair Admissions, a group founded by Edward Bloom, a legal activist who has organized many lawsuits challenging race conscious admissions policies and voting right laws, several of which have reached the Supreme Court. In 2016, the Supreme Court upheld an admissions program at the University of Texas at Austin, holding that officials there could continue to consider race as a factor in ensuring a diverse student body. The vote was 4-3. Justice Anton Scalia had died a few months before, and Justice Kagan was recused. Writing for the majority, Justice Anthony Kennedy said that courts must give universities substantial but not total leeway in devising their admissions programs. He was joined by Justices Sotomayor, Ruth Bader Ginsburg, and Stephen Breyer. 6 years later, only one member of the majority in the Texas case, Justice Sotomayor, remains on the court. The Texas decision essentially reaffirmed Grutter versus Bollinger, a 2003 decision in which the Supreme Court endorsed holistic admissions programs, saying it was permissible to consider race as one factor to achieve educational diversity. Writing for the majority in that case, Justice Sandra Day O'Connor said she expected that 25 years from now, the use of racial preferences will no longer be necessary. In the Texas decision in 2003, it seems that the justices were okay with the idea of racial diversity, meaning that we were in a changing landscape and that some of the lingering policies could look to be discriminatory in practice, and that if a school wanted to create their own diversity quota or policy, that they could do so if it was done in the bounds of the law, meaning you cannot discriminate against or for somebody based on the color of their skin. Now, what an interesting quote this is from Sandra Day O'Connor. 25 years from now, the use of racial preferences will no longer be necessary. To me, that creates the biggest glimpse into what we thought the future would hold for our nation and exactly how far we have declined from 2003. In 2003, we're looking to the future, or at least our Supreme Court justice is looking to the future, saying these racial preferences will no longer be necessary considering the progress that we're making. But here we are in 2022 And we're being told that the progress isn't really progress at all because we just can't shove all these people into a school based on their skin color. And that actually there are people who are just as disgusted that you're discriminating against them because you're discriminating in favor of somebody else. So, as we're noticing that the Asian American population is actually getting into school less, although their tests and their scores and their academic achievements tends to be on a higher level of success than your average diversity admissions. So here come the Debbie Downers. Several conservative justices said they doubted universities would ever voluntarily stop taking account of race. When does Harvard anticipate this will end? Justice Neil Gorsuch asked Mr. Waxman. Mr. Waxman responded, Harvard's view about when doesn't have a date on it. Justice O'Connor's statement suggested a deadline of 2028. Justice Brett Kavanaugh said the cutoff was looming. The current admissions cycle is for the class of 27. It's going to be too late to do anything about that cycle, he said. The next is the class of 28. The court's decision in the two cases, Students for Fair Admissions versus Harvard and Students for Fair Admissions versus University of North Carolina, will probably land in June. So we will be listening, waiting, hoping that the Supreme Court justices get this ironed out and are able to communicate to the American people that discrimination in favor of somebody based on the color of their skin is still racism. We should not be looking to fill a diversity quota based on the color of somebody's skin. The diversity quota should be based upon the academics and the achievements of the students. But I digress. We'll be watching this one. I look forward to hearing your comments about it. Anybody that disagrees or has anything that they want to add to this conversation, please feel free to put it in the comments section. That's all I have for you guys today. I will catch you on the next one.